Hello, good evening and welcome to another program on Law and Order, the program that highlights on a specialized area of law each week. Now, we all have heard of the term justice delayed as justice denied. We also have heard the term justice hurried could be justice buried. But where do we find a common ground on this? Now, in 2016, the Bar Association of Sri Lanka did a very important effort and put a report together looking into all aspects of how justice is delayed and how laws are delayed in Sri Lanka. And to talk about that report and what exactly is laws delays, what exactly is justice delayed, and how we can find solutions for that, I've invited to the program a person who was very much involved in this. He's none other than the youngest President's Council in Sri Lanka, President's Council Ali Sabri. He's also the Vice President or Deputy President of the Bar Association of Sri Lanka. Sabri, thank you very much for coming back on the show.
Thank you very much, Thank you for the invitation.
Yeah. How are you doing today?
I'm great, just after a session at the Supreme Court.
Yes. Before I go into the question, I'd like to show the report that you have put forward to the camera. And this is that report that was put forward by the Bar Association in 2016 about laws delays and justice delayed. In this report, Sabri, I noticed you had categorized we must congratulate on behalf of all the legal profession and as a country as a whole for your putting this effort. But coming back to the question, several categories of laws delays. Can you explain to me first
what
are those categories?
In fact, if you look at the laws delays, you ask a very pertinent question. What is laws delays? Yeah. Laws delays is that if you have a problem, problems, as long as this world exists, there will be dispute, there will be problem. So there has to be a mechanism which is effective, which is efficient to quickly solve the problem. So that's so if there is an inordinate delay in doing that, then there is a loss delay. Now we are lagging really behind in the whole thing. So that is why I think loss delays is really a big problem. Out of 184 countries which are surveyed by the World Bank, we are somewhere in the 142nd position. So among even in Asia and even in South Asia, we are lagging very much behind. So in that sense, loss delays is a problem which we need to solve as soon as possible. Now then you ask a pertinent question, what are the categories of loss delays? Loss delays could take place in the criminal jurisdiction, in civil jurisdiction, in arbitration, in commercial law, everywhere loss delays take place. Today I was in court, in a writ matter. Somebody was saying a case was dragging in the magistrate court for 19 years, and after 19 years he had been acquitted. And he's the principal of a particular Pirivana. So by the time he come back, 19 years have gone. And out of that 19 years, 16 years had taken for the Honorable Attorney General to send the report whether this could be prosecuted or not. So loss delays take place across the board, all over. So it's about the number of courthouses we have. We can discuss that in detail. The infrastructure we have, the system of the law which we have, and it's a broad area which we need to carefully look into, and separate mechanism have to be introduced one by one so that we meet those things, Chana.
Right. Among the four categories, I went through your report and I found infrastructure.
Yes.
Tell me, what are the problems we are having in infrastructure?
We have massive problems in the infrastructure. If you look at in Sri Lanka, we just have 106 courts or something. Those courts number
106 courts.
160 odd courts,
60.
Courthouses, which are not enough at all.
Right.
So we need the number of judges, very important. If you go to I'm sure being a practicing lawyer, you would have gone to magistrate court. If you go to a magistrate court, the calling cases are taken up till about 2 o'clock. The magistrate is inundated with cases after cases after cases. So by the time he called the cases, it's 2 o'clock. There is absolutely nothing he could do. Now, if you go to the district court also, if today a case is heard, the next date is 3 months, 4 months, 5 months down the line. That means if a day a case is going down, the next day will be 6 months down the line.
Right.
And some outstation court is about 9 months. Supreme Court today, I argued a matter and got the next day, one of my matters got postponed somewhere in July. July is 9 months down the line. So number of courts are inadequate, number of judges are inadequate all over the country, whether it's magistrate court, district court, commercial high court, court of appeal or Supreme Court. Number of judges and the number of courthouses are inadequate. That's one side of the problem. The number of the courts are the problem. For example, if you have a high court takes average 10 years to conclude an existing case. Only in the High Court, original court,
yes.
apart from the Court of Appeal and the Supreme Court. So in that sense, it takes a lot of time. That's one side of the problem. Then in the High Court, if you go there, whether you have proper courtrooms, whether you have support staff, whether you can take your proceedings on time, whether you have the interpreter, whether you have the mudliya. So all these things are problems which we need to scientifically look into and make some tangible, long-standing, viable solution, not ad hoc solution to meet a problem at that point in time, but a long-term vision with a goal to achieve and take Sri Lanka at least within first 50 in the world.
Right. One of the other categories you have mentioned in this report was judiciary. You mentioned about quotas. Is there, what are the issues you found in judiciary per se contributing to loss delays?
Yeah, I think different areas are contributed towards it. In the judiciary per se, the issue is the number of judges. If you look at Supreme Court, we have 11 judges. And there are 2 courts sitting every day. And every court has about 30 to 35 cases mentioned in the morning. By the time they finish the mention list, it's about 11:30. So other than 3 or 4 cases, they can't practically take up all the matters.
Right.
So as a result of it, the cases that have been heard today, if it goes down to 6, 7, 8 months down the line. And even on that day, if it is not to be taken up, what would happen? So the number of judges are the main issue. Then of course, we do have situations where for example, commercial courts, if it is an IP case, if it is a company law case, if it is a case involving patent, you need to have certain amount of knowledge on that particular area, specialized knowledge.
Yes.
You know, so whether we have specialized judges, we have commented on that. Specialized judges in certain areas, good jurisdictions have those things. Now we need to look at that also. If the commercial judges mean some of these matters are cases involving, say, billions of rupees worth of property, projects, all those things. A simple mistake could cost a company or a person billions in real terms. So therefore, it's important that we need to have specialized judges in some of the sensitive areas.
I remember when I was about 2 years ago, there was this US case, biggest patent case where Apple was awarded $1 billion.
Correct.
And in that case, when I was reading up, I found the judge was a ad hoc judge appointed to hear that case, who was a patent attorney.
Exactly.
Now, what I'm asking is that kind of thing possible in Sri Lankan system, or should we change towards that?
At the current situation, it's not possible, because only judges who are appointed by the Judicial Service Commission through the various mechanisms are entitled to sit in judgment and hear it. So that's the power which is vested with the Judicial Service Commission, or otherwise senior judges like High Court, Supreme Court and Court of Appeal, His Excellency the President himself has to appoint with the concurrence of the Constitutional Council now. So that's an area, I think I'm happy that you brought in. That's an area we must look into. At least you should start thinking about it, negotiating about it, discussing about it. And then in those kind of important cases, you need to get that kind of judges who could grasp it and hear the cases. So
will that not affect the independence of the judiciary?
That will at the present status now. But on the long run, like other jurisdictions have found a way, if they are they have a proven track record, coming with impeccable the history and knowledge, and they will they cannot be questioned, or their integrity cannot be questioned. What is wrong in them having it? Because we informally had that arrangement with the arbitration anyway.
Yes, right. Increase in litigation, is it happening in Sri Lanka, and has it contributed to the loss delays?
Increase in litigation, I don't think people are litigating anymore for fun, unless it's actually that's a wrong notion. But some of the lawyers are contributing to this. They think that if you settle a case fast, quick, expeditiously, they will lose out. No, it's not so. And all the cases will be over, and therefore we will not have an impact on that. So if that is the case, are the attorneys in UK, USA or Western countries doing badly? No, they are doing fantastically well. They're charging. Now recently, if you don't mind, I will just, this thing, one of my clients wanted to consult attorney or a Queen's Counsel in UK. They send us a quotation for 14 hours of work. They wanted 30,000 pounds, 30,000 pounds for 14 hours of work. So that you are talking about 6 million for 14 hours of work. That's the kind of money they are making. So that is because people have faith in the system. People are willing to pay because there is an end in the sight. So in that sense, I think in Sri Lanka, unless you have no other alternative, you won't go for litigation. People are sick of litigation because once you get into court, especially a civil matter, even a criminal for that matter, and it takes years and years of hard work, time, opportunity cost, money, everything. So therefore, I don't see a litigation. Not that litigation are not there. People have problems, they will go. But the willingly taking a risk or poor point, they are not litigating. If you have any other choice, they are not litigating. As a last choice, they go to courts.
Right. One of the other areas in this report was the unethical conduct of attorneys at law. I might qualify that by saying certain attorneys at law. In this report, what did you all find to say that?
Yeah, in fact, that's let's face the facts. You know, we must, before we point our fingers at others, we must kind of direct the searchlight inwards and find how who contributes to the loss delay. System contributes. Laws per se, archaic laws per se contributes. The number of judges and the number of courthouses and lack of infrastructure is contributed. And the actual attitude of the lawyers per se also contributes to a great extent. Then we need a paradigm shift. What is that paradigm shift? The paradigm shift is that we need to see that some or other find quick solution to their problem while preserving those ingredients of a lawful trial. As you very correctly point, we can't force things in and then expedite it in such a way that justice hurried is justice buried. So in a way we have to have a fine balance. But some of the lawyers, we know that. We know that some of the lawyers of our colleagues, very few, but I can say massive majority of the lawyers are very law abiding. They are there for a cause. They do a very respectable job. Few of them tarnish the image of the profession and the associations and everything. And they are into some mischief. That is one side of the problem. But we have a mechanism for that. Supreme Court is looking into it. Bar Association has our own professional committee which looks into this. And if we have a problem, somebody report to us, we take a note down of it, and we have a committee which will have an inquiry on that. And if we find there is anything to be serious in that, we refer to the Supreme Court. The Supreme Court either suspend them or remove them from the list. Last week in the Bar Association Executive Committee, we decided, after looking at 5 reports from subcommittees, to direct the report to the Supreme Court to take action. So that is there. But we are also looking at it. Right now we are working on a project called Future of the Legal Education. In one of the project is to introduce CPD, that is Continual Professional Development. In that we are proposing that we must introduce, like any other advanced jurisdictions such as UK, Australia, America, where even after you take oaths, you must continue to license yourself and update yourself in the area of practice what you are intending to do. Because unless you are a current lawyer, unless you are current with the development, you are not capable of advising somebody else. So we need to slowly introduce that. I think there will be a little bit of resistance. But to be fair by the Bar Council, when we put to the Bar Council endorsed it, the need for a continuous professional development. So coming back to your question, majority of the lawyers are very law-abiding, hard-working, and they respect the system. While there are few people or very minority kind of people who have done, who have brought a lot of discredit to the profession. We are taking action against them, and there is a process in place. While we take steps on the long run to improve the professional standard of the lawyers by introducing CPD.
Right. You mentioned in your answer earlier that about the archaic laws that also contributes.
Yes.
I know it will be unfair for me to ask you to name all the archaic laws, but at least in your day-to-day experience, what are the areas of law? Is it procedural, or is it substantive law, or is it both? What are the most areas of law which needs immediate change in order to stop contributing for the loss delays?
Good question. Very good question. I think it's both substantial as well as procedural laws are there. Some of those things are very archaic. For example, if you look at the Civil Procedure Code, now there was a certain amendment brought in recently to introduce a pre-trial. Now that is important, but the problem is whether that pre-trial, what was meant in the pre-trial, is being implemented in that way.
Right.
So now, for example, our system of justice is you're on the basis of advocacy.
Right.
You know, it is not inquisitive, inquisitorial rather. It is kind of adversarial. As a result of it, people are just taking objections to everything. For example, if a simple land dispute, I had a case. A and B had a case. I was appearing for A. B was represented by some other President's Counsel. It was a prestige battle. It's about somebody had encroached one perch of a land from each other. Now, I went through and saw that no, I have not encroached anything. Went through the case, took commission, done everything, and led about 5-6 people's evidence, including the pedigree, deed, and everything. Other person also did. Case went about 7-8 years. Ultimately, the judge decided nobody had encroached anybody's one. So, but if it is in advanced jurisdiction, what the judge would have done, if the pre-trials are properly worked, if it is in fact an inquisitorial process, he would have called both sides, sit in a conference, ask them to put each other's documents and find out, okay, what's your case? This is your dates. These are your dates. You are saying that your dates are this. You are saying that these are your dates. Put your plan. And he would have given a commission to a surveyor and asked them to come show me whether who had encroached whom. Now that's how it works in other countries. So we need to empower the judges to do that and train them and ask them to understand the new procedural law. So it's one of it. The other one is, for example, look at when the whole world is changing. Now breakdown of marriage principle. If A and B are married and the marriage is no longer working, and they living together can create problem for themselves, physical harm, children and everybody. You don't allow them to get divorced. You still have to prove one of those limbs.
Yes.
What are those limbs? Either you have got involved in adultery or so-called the malicious desertion.
Yes.
Whereas in other countries, if X and Y are married and X doesn't want to fight, now I have a case in the Supreme Court. 22 years they have not lived together, but wife is not giving the divorce. So what's the point? I think I had a couple of clients from Australia, Sri Lankans, but Australian citizens now. For them, just 1 year of separation is good enough to establish breakdown of marriage. So that's a separate jurisdiction. Divorce is given. Nobody is forced to stay with each other. Second one is about how to divide your property. That's a separate
case. Yes.
And the child custody goes to a separate.
Right.
Very efficient.
Very efficient.
So child is not being used as a pawn to demand for your divorce, so deny your divorce. So I think these are areas. I'm just giving you 2 examples.
Exactly.
So one is Civil Procedure Code, need urgent, efficient amendment on par with the other international jurisdiction. Divorce law need matrimonial law need urgent attention of the legislature, because you can't force people to be in marriages against their will. Maybe you can say anything in the world, but at the end of the day, it's dangerous to live under the same house when you don't want to live with each other.
Right.
And we know history. from Sathasivam to Father Matthew Perez. All of them, were denied divorce, and you can't establish the divorce. And when they don't want, ultimately they get into totally high-handed activities, which goes into murder of your spouse.
Right. I'll couple these two questions together due to saving time. Other than what you propose in this report, what are the proposals you have done to change the situation, and what would be the Bar Association doing about it? And the other thing is, this is of course about the arbitration. Now, we all thought when arbitration came in, it was going to be a fast-track process. But people find when you get the arbitration order, you can go to appeal process, and enforcement process can get delayed. Shouldn't it be looked into changing as well?
Exactly. I'll start with your second question. Arbitration is a huge disappointment, major letdown. Who had contributed to this? The arbitrators and the lawyers themselves. They have made it now arbitration is an alternative to the court's procedure. So people are, because court procedure is not working, taking time, time consuming, not effective, you have brought the arbitration. Now we have all got together and made arbitration is also just like the court, at an additional cost. So we need a paradigm shift on that. And I don't think that retired judges, whether from the Supreme Court or Court of Appeal, other than the exceptions, are ideal people to sit as arbitrators. Because their mindset is about the courts and how courts work. In other countries, arbitration lawyers, arbitrators are different. They are commercially oriented people. They need not to be lawyers all the time. And as a result of which, they sit day to day and do those things. Here is a situation only in the evening, 5 o'clock to 6 o'clock, 1 hour, just like court cases. It continues, and therefore lot of people are not going for arbitration. And we also advise our clients not to get into arbitration, because it's not. And then a huge problem about the integrity of the arbitrators per se. Not every one of them, but most of them, or fair percentage of them, because once you enter into arbitration and arbitration judgment is given on merit, you can't challenge it. So it's dangerous. So unless the integrity is kept and top-notch professionals with highest the professional integrity are sitting, people will never go there. It's very dangerous. You can't appeal also. So that's one side of it. The other important thing is that you asked, what do you suggest apart from this? We are suggesting a certain amount of amendment to the Supreme Court rules to have separate judges for hearing separate kind of cases, and at least 3 benches to sit. And judges must be empowered. The Supreme Court judges, number of judges need to be increased, and those judges have to be empowered by at least giving a team of 2-3, like in other countries, research assistant, who could do their help and all those things. Now these judges are totally overworked. Chief Justice need about 3-4 High Court judges as registrar to help him out on administration, on research, on other things. Now he on his own, how can he do? He is the head of the Judicial Service Commission, he is the head of the legal administration system. So he needs support to do that. So in view of that, what we are suggesting is to empower the Judicial Service Commission, increase the number of the Supreme Court judges, change the Supreme Court rules, and look at that afresh as to how we can efficiently man the whole legal administration system.
Is there one last word you would have for the lawyers, if you can tell me in 30 seconds, to avoid contributing to lost delays?
Yeah, I think lawyers should feel this, that they must work, they need to have a paradigm shift, all of us, to see that this system must work efficiently. When the system works efficiently and you get speedy justice to the people, more people will start litigate. When more people come in, all of us will be benefited, and the country's status in the world also will go up to have a effective legal administration system.
Ali Sabri, President's Counsel, thank you very much for joining us.
Thank you
for those very valuable thoughts, and we wish you success in your efforts to reduce this lost delays and everything you're doing. Thank you.
Thank you very much for that.
That's Law and Order for you today, and we'll join you next week at the same time for another program on Law and Order. In the meantime, if you want to watch our previous shows, you can go to our website, channeli.lk, and go to the drop-down menu, Law and Order, and you can watch all over our episodes, the previous episodes once again. Have a good night and a good weekend.